You know, this seems a little shocking to a lot of people. However, it's not that much of a surprise, is it?
It's not that much of a surprise, only because 26, I think it's 26, 28, there's been disputed reports, but about 26 to 28 states and the federal government are allowing this. That is DNA to be taken in serious cases. So it's not that serious, or shocking rather, for those reasons. However, what is now disturbing people is the level of searches has now changed. Before, you know, it's only search incident to a lawful arrest. If the police officer is in danger, he's going to look for weapons, and if there's relevant evidence to the arrest, then the search takes place.
I want to talk more about that, but before we do, let's just take a step back and talk a little bit about the behind the scenes of this ruling. Of course, one of the dissenters was Antonin Scalia, and his briefing was scathing. So let's put up just a bit of what he wrote.
Sure.
He said, "Make no mistake about it, as an entirely predictable consequence of today's decision, your DNA can be taken and entered into a national DNA database if you are ever arrested, rightly or wrongly, and for whatever reason." So he really is expressing his disdain not only at the concept, but really at the rationale of the other justices.
He's attacking his colleagues, which is also just incredibly astounding. But let me just explain this. The reason that Scalia is pointing this out is because he's sending a message to the public that the majority is saying, okay, we're going to take your DNA, and we're going to take your DNA for identification purposes. And what Scalia is saying, he's saying, no, you're misleading the public. You are lying to the public. You're not doing this for ID. You're not doing this like, I'm asking you, Debbie, what is your name? What is your social security number? You're using it as a guise, because what you're really doing is you're investigating crimes. And the problem with that is the Fourth Amendment says you cannot do that. You cannot have suspicion-less searches. Otherwise, I could just walk up to you on the street and stick a Q-tip in your mouth and get your bodily fluid. That's what Scalia is saying.
And this is really scandalous. I mean, let's just be real. The Supreme Court justices write dissenting opinions all the time.
Yeah.
But they, to my memory, and you correct me if I'm wrong, don't seem to take their colleagues to task and accuse them, as you've said, of lying. That's really.
Yes, he is. He is lying. He is saying that they're lying. Also, because this case, you know, it came from this Maryland case involving a gentleman named King. And in that case, they took the DNA and said, oh, we're doing this for identification purposes because we want the ID for the arraignment. Now, that takes a turnover of within a few hours. And everyone in this country knows DNA results take up to 2 weeks. So he's saying, hey, majority, you're lying to the public again, relying on King, saying you're doing this for identification purposes, when we have to have an arraignment within, let's say, 24 hours. And so it's disingenuous at that point to say, I need this person's DNA profile to make a bail application. So that custody is at issue.
It really does make one wonder what else is going on behind the scenes for him to feel emboldened or maybe even embittered to do something like this.
And because he's so conservative, too, that he's siding along with the liberals.
Absolutely.
He's never at that table. So.
All right, right. Okay, so let's march forward a little bit. He also wrote this in his decision. It says, today's judgment will, to be sure, have the beneficial effect of solving more crimes. Then again, so would the taking of DNA samples from anyone who flies on an airplane. Surely the TSA, or he writes it out, Transportation Security Administration, needs to know the identity of the flying public, and then he goes on. And this sort of speaks to this taking the DNA samples upon arrest, speaking to the sliding, slippery slope of this issue.
Right. He's getting on that pulpit, and again, he's telling the public, be warned, because now if they're going to say, the government is going to say that we want your identity, then we can take that Q-tip and put it inside your mouth for any reason. For your child who goes to public school, we need to know that person's identification, the DMV for a driver's license, and the TSA. But he's also being kind of sarcastic in that line that you just read. You can see that he's being very
like
sarcastic.
TSA wants to know who you are too. Yeah,
Right.
Everybody's going to want to know who you are. Yeah, it's such an interesting ruling, and I think it's going to bring up a whole lot of debate, especially in law classes around at law schools in the world. Okay, let's move on. Trayvon Martin's trial starts next Monday, June 10th, and there's been a flurry of activity over the last few weeks, not the least of which the defense releasing all of this defamatory, the family would say, information, texts, photos, and that kind of thing, which they knew in the first place the judge was not going to allow. What game are they playing here?
Oh, this is like law school 101. You know, speaking of law school, we know that victims' character evidence is not going to be allowed, okay? But Mark O'Mara is trying to essentially taint the jury pool in his favor. He's trying to set up this self-defense for George Zimmerman. And how is he trying to do that? Okay, he's putting out into the media photographs where Trayvon is looking pretty aggressive. I think there's something with him holding up the middle finger, and you know, there's
with gold teeth
and the smoke rising in his face. And then you have constant articles about these text messages between Trayvon Martin and his friends, but specifically, this is the real issue that I think O'Mara had a chance of bringing in. There is a witness, and she is supposedly a she, known to be witness number 8. And that witness number 8 was Trayvon's girlfriend at the time. On the day of the incident, there are text messages between Trayvon and witness number 8 that they were fighting. These are hostile messages. Why does the defense want them in? The defense wants to show Trayvon's demeanor and state of mind at the time of the incident. So if I am angry and I am worked up and I'm hostile and I just got in a fight with my girlfriend, I hang up the phone and I'm in that rage, I am more likely to be the one who started the fight. And starting the fight, that's the concept of initial aggressor, which is what the defense has to prove for self-defense.
We're almost out of time, and I want to get to that. I want to ask you so much about that, too. Is that an effective defense? But also, does this set up Trayvon's family, then, to be able to sue even Mark O'Mara for defamation?
Absolutely not. Absolutely not. I think.
And is it because he's no longer living? Is that why there's no legal?
No, actually, that's a good question that you bring that up, but it's not that. It's that the burden is to show in defamation intentionally false claims or allegations. Mark O'Mara is not doing anything intentionally false. There are these documents and photographs that he's trying to introduce into evidence, but they're not false. They're just actual pieces of evidence that he's trying to introduce. And you have to weigh that against his ethical duty as an attorney to zealously represent his client, which is what he's doing. It's not a personal attack on Trayvon Martin.
No, I'm sure that it feels very personal to his family, even though it's not
course.
intended to be. All right, Seema, we're going to have to leave it right there, but we'll talk some more later, okay? Seema Iyer, thank you very much.
Thank you.
Appreciate it.